Hello, everybody. Welcome back. I hope you enjoyed your little break. My name is Kyle Buller. I'm one of the co-founders at Psychedelic today, and I will be moderating this presentation with Joseph Rhea. So really excited for everybody to be here. How's everybody doing? How are you enjoying the Psychedelic Liberty Summit so far? Drop that in the chat box below there. If you have any questions throughout this time, be sure to just drop your questions in the question box there, not the chat. Sometimes these questions get a little lost in the chat room, so please utilize the Ask a Question function. So this presentation is called Psychedelic Integration, Administrative Law and Criminal Law Implications for Practitioners. This presentation will first discuss the history of psychedelic integration and its reemergence in the current psychedelic renaissance. The discussion then moves on to possible legal issues facing practitioners with and without professional licenses. All practitioners need to be mindful of the law of conspiracy to distribute controlled substances such as LSD and DMT. Because psychedelic integration is not a recognized modality in any state, licensed practitioners, doctors, therapists need additionally to be mindful of the administrative law rules governing their services. Finally, every person working in this groundbreaking area needs to explore for herself or himself the line between legal imprudence and excessive caution. Psychedelics offer exciting new possibilities for healing, and the legal component of this needs to not be stressful. So as long as we're mindful on the issues in advance. So yeah, this is a wonderful topic, and this is something that we chat about a lot, actually, on our side at Psychedelics Today and our education side. So I'm excited to introduce Joseph Rhea. Welcome here, and I'll do a little bit of an intro, and then if I miss anything, you want to fill that in, Joseph, feel free to. So Joseph is an attorney at Palm Springs, California. Joseph grew up in Eastern North Carolina and received his PhD in sociology from Harvard. He taught in areas of inequality and social movement organization at Harvard and Arizona State University. He's the author of Race, Pride, and American Identity. As a lawyer, Joseph first represented indigent defendants and then became very involved in cannabis legalization in California. Joseph is a member of Chacruna's Council for Protection of Sacred Plants and is eager to help with legal issues regarding safe access, and is particularly interested in those projects that address inequalities of access. So welcome, Joseph. Really excited to hear what you have to say.
Great, thank you. And wave at me if there's a volume or a problem or anything there. Hi, good afternoon. I'm in Palm Springs, California today. I wish we could be together in San Francisco. But let me tell you a little bit about what I'm going to cover here today. This was going to be less of a lecture and much more interactive when we were going to be doing it in San Francisco. So let me kind of walk you through where I'm going to be going here today. So the talk that I'm going to be doing here is primarily for people who are interested in the whole world of psychedelic assisted therapies, but I'm not going to delve into two types of work that are going on right now. First off, the government approved clinical trials. That's a whole world unto itself. And then I'm not going to get into the details of legal issues regarding the Oregon initiative very much here, because there's obviously an exciting psilocybin initiative in Oregon. How that would interact with potentially with federal law is something I'm not going to get into too much here today. So this topic is really going to be very focused on people who are excited about the healing potentials of the various psychedelic substances, want to be involved in that, but aren't quite sure what to do and what's legal, what's not legal. Maybe not even clear whether or not what they're doing right now is legal or illegal. They're trying to figure it all out here. So this is sort of a guide to where you are in your practices. You can, by the end of this, I'm hoping you'll be able to look at what you're doing and say, okay, these are things that I'm doing that might be risky. These are things that I'm not doing that I could be doing, and so on, like that. Now, the way I come to this is I worked in the cannabis legalization field for a lot of years. And toward the end of it, just before the passage of Prop 64 in 2016, there was this wave of people coming into the cannabis industry. Everybody wanted to make money in the cannabis industry, but it hadn't fully legalized. There weren't permits available, things like that. And so lots of people came pouring into the industry, and a fair amount of people, I should say, not a lot, but a fair amount of people ended up getting arrested. And they would very often be like, well, wait a minute, everybody else is doing this. How come I got arrested? They would ask. And the short answer to that was, while more people were doing it, the legal risk profile of the activity actually hadn't changed. It was just that there were more people engaged in the conduct. So just because everybody's speeding doesn't necessarily mean that the speed law has changed. So what I observed back then was a lot of very well-intentioned people who were inferring safety from crowd behavior. This is a very bad idea. Do not infer from the fact that other people are doing it that it must be okay. It's a real human temptation to do that once you get 3, 4, 5, 10 people doing something to jump to the conclusion that the activity doesn't have risk. So this talk is really going to be toward helping people answer the questions: where am I in space and time? What's going on around me, separate from the group behavior that I might be observing? So that's kind of the purpose of this, is to really help people make decisions about their own practices without being naive about risk profiles. So we're going to get into this now. So that's the goal. That's what I want to try and accomplish for you with this talk, is to give you a kind of toolkit for making some decisions. Okay. So everybody who's getting into this seems to me to be getting into it for the same reason, which is a desire to help other people, and because of the enormous healing possibilities of these substances. Now, there is a spectrum of involvement of a therapist, and I'm going to kind of take it from the most risky down to the least risky in 7 steps. And what I'm really going to be doing here is describing 7 sort of possible profiles of a practitioner regarding psychedelic therapies. So you might have a therapist, kind of at the most extreme, who's providing both the substance, say MDMA or psilocybin, and the setting. Okay, now there are people doing that, and that's one level of involvement. You could have a therapist who recommends a specific trip provider to clients as part of their ongoing therapy. Doesn't actually have any direct involvement with the administration of the psychedelic substance, but is making active recommendations to somebody who's doing that. Third level of involvement is a therapist who provides the setting, but not the substance. So this is essentially trip sitting for an existing client or somebody who's coming in. The fourth level is a therapist providing before and after experience integration as a modality. Okay, they're offering psychedelic assisted therapy, self-conscious as a modality, but they have absolutely no involvement in procuring or referring anybody to the actual delivery of a controlled substance. Okay, so that's kind of fourth level. And you can see we're kind of moving away from criminal seriousness to maybe professional licensing seriousness on out into a world of free speech as we go down this list. So the fifth level of type of involvement a therapist might have is a therapist meets with a client before an experience and after, but not offering psychedelic integration therapy per se, but maybe, for example, making a generic recommendation to an existing client along the lines of, you seem to be stuck on your anxiety here. You might want to, read Michael Pollan's book and think about doing psychedelics. So this is essentially a therapist who's making a recommendation in the context of a duty of care, but not actually having anything to do with the delivery of that service, either at the talk therapy level or at the delivery of substance level. But again, just making a recommendation in the context of an ongoing therapeutic relationship. Sixth sort of level here, and again, we're moving away from seriousness, is a therapist who meets with a client after an experience only, but advertising that he or she does do that. So somebody who offers psychedelic integration, but has no prior duty of care to the people involved that it is any way intersects with the delivery of the substance. So you have somebody who's advertising, I'm happy to work with people who've had these experiences, but doesn't have any prior involvement. And then finally, and obviously the least serious, is a therapist with an existing or new client, and the client has a psychedelic experience without any involvement with the therapist's input, and then the therapist offers integration services after discovering this from the client. Obviously, we're moving off into completely legal at that point. So what I'm going to do is, now that I've given you sort of a range of possible conduct that you could be involved in. So there are people out there who are procuring, delivering, et cetera, all the way down to people who are just encountering this issue in their professional practices. So now you've got that range. Let's start talking about the law that applies to that range of conduct. So we've got a range of conduct, and now we're going to look at the laws that apply to them. So I'm going to start off with criminal law here. So with criminal law, it's a good idea both to know the rules and risks. So let me start off with this. I'm going to state the applicable criminal law. And then I'm going to move on after I've explained what the three types of criminal laws are that apply in these settings. And then I'm going to talk about how people actually get prosecuted, why some people end up in jail and other people don't. And then I'm going to conclude the talk again by giving you some suggestions about how to assess your own relationship to these issues and then your own risk profile. Okay. So there are three types of criminal laws that come into play in psychedelic-assisted therapy potential. Okay. This isn't to say that if you're having something to do with this field, you need to worry about it. You need to first off start off again with what kind of conduct am I engaged in? Now let's take the criminal cases here. There's three different types of laws that apply. These are the laws for sales and furnishing of a controlled substance. Then the laws for what are called drug house laws, for opening up a space for the consumption of drugs. And then finally, conspiracy. So let me walk through each of these three. Now, these are criminal penalties, and they're all felonies I'm going to describe here. And I'm not going to talk about professional licensing consequences in detail on this conduct, because if you get a felony conviction, you will have licensing problems in any state. So, well, certainly in California. Maybe there's a state out there that I don't know about that looks the other way. But in any event, in California, you're going to have licensing problems if you have a felony. So let's start off with sales. Now, this is a tricky one because in California, sales and furnishing are the same thing. Now, let me repeat that and make sure you've completely assimilated the meaning of this. Sales and furnishing are the same thing. Giving something away is the same thing as selling it for criminal liability in California. Okay. So sometimes you'll also hear people talking about how, well, we're a donation-based service, or we have an energy exchange or something like that. None of this has any legal significance. The only thing that matters is yes or no, was a substance sold or furnished to another person that is on one of the California schedules for drugs. If the answer to that is yes, you got a real problem here. And the penalties are nasty. So for MDMA, that sales of that gets prosecuted under 11379, the Health and Safety Code in California. It carries up to 4 years incarceration. The penalties for that go up dramatically if the state can prove that the controlled substance was transported across non-contiguous county borders in California. And I'm just going to use California as the example all the way here because it's what I know. So, for example, a psychedelic-assisted therapist who's in, say, San Mateo County and gets arrested in San Francisco County, or the other way around, for providing psychedelic-assisted therapy and is furnishing the controlled substance, is facing 4 years incarceration, confinement. Now, the same therapist going from, say, San Mateo down to Los Angeles and transporting, if it can be proved that there was transportation of that same substance, the penalty pops up to an eye-popping 9 years in custody. So this is really, really aggressive. Okay, so the penalties on these things are gigantic. And again, you can see where I'm going with this, which is it's very easy to get lulled into a false sense of security by peer groups or just by people you hear about. But you can just look at the Health and Safety Code. You don't have to take my word for it. Just Health and Safety Code 11379. And you're going to see there are these vicious penalties. Now, most other drugs, LSD, DMT, ayahuasca, bufotenin, ibogaine, all of the major psychedelics other than MDMA be prosecuted under 11352 Health and Safety Code. That carries a 5-year confinement term. And as with 11379, the penalty pops up to that eye-popping 9 years on a non-contiguous transportation. Okay, so the penalties here are gigantic potentially. And you need to just be really clear about that. Because again, back when I was doing a lot of marijuana, a lot of cannabis cultivation cases, people would get lulled into this false sense of security about that and then run into these big penalties here. So remember, sales in California, even though California has the appearance of being a liberal, progressive state, our drug laws suck. Okay, they still really stink. And it's very easy to get lulled into a sense of safety in California, particularly if you're in the Bay Area, and think, all is well here. Nobody cares about this. I don't need to even think about this. Again, just look at the Health and Safety Code, and the penalties are sitting right there. Now, the second type, and again, that's the area of sales and furnishing. Okay. The second type of law, the criminal law that can come up, is what are called drug house laws. And these exist at the state and federal level, but I'm only going to talk about the state level right now. So in California, this is Health and Safety Code 11366. And drug house law basically makes it illegal to continuously or repeatedly use a property for the provision of a controlled substance. Now, it kind of street level enforcement. This comes up with, like, say, a hotel owner in a tough part of town who decides that he's just going to look the other way when drug dealers are using rooms at the hotel or something like that. That's where criminal liability pops up there, and that's sort of the stereotype of it. But it applies in psychedelic assisted therapy too, in that a therapist who simply lets out the room and says, okay, anybody can come here and I'll trip sit, is repeatedly letting out a commercial space, place of business, or a home for the purposes of violating state drug law. And so the drug house laws apply. Now, the drug house laws carry a penalty of 3 years incarceration, not as bad as sales or transportation, but still a big whack, and it's a felony. Okay, so you need to kind of be aware of drug house laws. And the reason why these laws are, I'm really kind of emphasizing this, is that a lot of very innocuous sounding conduct can get swept up in here. So like, oh, I didn't have anything to do with it. I just let them use my house. Over and over again, you do that repeatedly, that's an 11366 violation. So there's a lot of ways. And I've seen this my whole career as a criminal defense lawyer. There's a lot of ways to sort of sleepwalk into criminal liability. And then the last one is conspiracy. Okay, so conspiracy laws exist at the state and federal level. At the state level, it's Penal Code 182. Now, conspiracy as a concept is kind of an interesting legal construct. It comes from the Latin phrase conspire. So conspiracy, conspire. And that literally means to breathe together. Okay, so what happens under conspiracy laws is that people who have a fairly small role in a larger criminal endeavor can take on the full liability of the criminal endeavor if two things happen. They know about it. They've acknowledged what's happening, and they've taken an affirmative step. Now, the kind of classic kind of gangster version of this is, say there's a murder for hire scheme going on in Los Angeles somewhere, and there's some poor schmuck who's getting paid $1,000 a week to wash out the car or something like that. But he knows exactly what's going on. Now, that guy signed up to wash cars. He didn't have anything to do with killings or anything like that. But if the government gets wind of that, they're going to grab that guy and make it very clear to him that he has purchased the full liability of this heinous crime by conspiring, by breathing the air of the conspiracy. Now, conspiracy laws are enough to give you the heebie-jeebies because they're vague, they're intended to be vague, and at the federal level, they have absolutely grotesque teeth. You can years up for racketeering. I'm not going to get into any of that there. But at the state level, the way the state of California handles this is that somebody who is involved in the larger conspiracy, even as a small player, takes on the liability of the bigger player. So, coming back to our therapist example here, a therapist who routinely recommends clients to another party, knowing that that other party is going to be providing, furnishing or selling controlled substance to clients, is part of a conspiracy now. So you have multiple people. You have a therapist who has taken an affirmative step by referring people, knew what was going on. So that therapist has made his or herself a instrument of the crime being committed by the person selling or furnishing the controlled substance. So that is to say, the therapist has breathed the air, breathed the air of the conspiracy. Now, California law just simply applies the original liability standard for the heavy to the lightweight. There's RICO statutes have these creative. I mean, it's terrifying what happens at the federal level, but at the state level, the rule is very simple, which is that the small party just simply takes on the liability of the larger party straightforwardly. So somebody engaged in that course of conduct on a regular basis has potentially got the liability simply of the person who's engaged in sales. Okay. So now, again, those are the three felony conduct levels that we have here that psychedelic assisted therapists need to worry about. I'm not going to get into simple possession and things like that. Almost all simple possession of controlled substances in California, just you or me on the street type thing, are eligible for PC 1000 diversion, which is a good program in California. So I'm not going to get into that. I'm literally just focusing here on cases where you have multiple actors, and that's really where you get the liability issues. Okay, so that's the world of criminal law activity here. Now, I'm a criminal defense lawyer, and I think an occupational hazard of what I do is a certain kind of paranoia, because I read these statutes and they have these gigantic penalties, and oh my god, and it is terrifying. And people do run afoul of these laws. The purpose of my talk here, though, going with this, is not to scare the hell out of you, but so much as just make you aware of what's happening in the larger environment around you, rather than relying on pure conduct. Because if you get anything out of this talk at all, do not rely on pure conduct as a gauge of legality. Single worst thing you can do. Okay, so those are the three types of criminal liability that you need to think about here, be engaged in this area. Now, if you don't have any professional licenses, you're trip sitting or whatever, or offering coaching, you don't have to worry about professional licensing issues for the obvious reason that you don't have a professional license to worry about. Now, I'm going to talk a little bit now about professional licensing issues. When we were going to be doing this in San Francisco, this was going to be a little bit more of an open dialogue section of the presentation. And that is, it's very difficult to see professional licensing actions across state lines. Like, I don't have a body of case law that I can point to about this. So I go, hey, in Florida, da 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 happened like that. So what I'll do here instead is just articulate some basic principles of administrative law to remember. Professional licensing agencies, and again, if you don't have a license, this doesn't matter. Professional licensing agencies have a lot of discretion to police professional boundaries and norms. So, for example, let's take a fun example. Let's say there's a dentist out there who suddenly flips out and starts selling bottles of sugar water to his clients as a cure for gum disease. Okay, well, that's not illegal. I mean, sugar water is perfectly legal, but that guy or gal is going to hear from their professional licensing board because they're taking actions that are completely contrary to the norms of the license. So that's when professional boards get involved. Now, even though there's nothing illegal about that conduct. So when you're thinking back on that range of activity that a psychedelic practitioner could be involved in, as we're getting towards 4, 5, 6, 7, as we're going down the range there, and you're getting more purely into professional licensing issues. If you don't have a professional license, forget about it. And if you do, then it really comes down to questions of, do you have a duty of care with this person? And are you offering a modality that is not recognized by your license? And so that's sort of the space that you're in. Now, just kind of flipping back through very quickly through that kind of 7-level area we have here. In the first example, I was using somebody that was actually furnishing and sitting for clients. That's straight sales, pure criminal conduct. Second level is a therapist that provides setting but not the substance, trip sitting only. There you've got drug house law applicability plus the unapproved modality at the licensing level. Then in the third level, therapist who recommends someone to a specific trip provider as part of their ongoing therapy. That was conspiracy law and an unapproved modality during a duty of care. So you can see why I tiered this way. Now, our fourth example was a therapist who meets with a client before an experience and after, but not involved in any kind of trip arrangements, didn't do anything more than making a recommendation. When you get into that level, you're getting into First Amendment free speech issues. And therapists still have free speech rights in regard to their clients. If at that fourth level that we're discussing, there is a psychedelic assisted therapy being presented as a package, then you're into duty of care and modality issues regarding professional license. Doesn't matter at all, though, if you're doing this as a coach, because you don't have a license issue. The fifth level was a therapist who meets with a client before an experience and after, but just simply has a recommendation. Okay, and that's it. It's not presented as a package. Now, that therapist is very straightforward. That's fairly straightforwardly free speech is the argument there. You might still hear from a licensing board about it, but it's something that's just presented as a recommendation of something to explore in passing. I think there's a Ninth Circuit case, Conan v. Walters from 2002, where the DEA tried to bust up doctors who were recommending cannabis for their patients. And the Ninth Circuit there ruled that, no, that's a free speech act. Doctors can have opinions there. And essentially, that's kind of where I think that conduct falls. Our sixth level was a therapist who meets with a client after an experience only, but advertises a willingness to do specifically psychedelic integration work. It's always possible to get paranoid here and be like, oh, that's not a recognized modality and all this kind of stuff. But if all of the illegal conduct is happening prior to any duty of care attaching or any involvement in the therapist, I think, and again, this is just an opinion because we don't have a body of case law that I can point to here. I think this would be at most something where you'd be likely to get a letter from a licensing agency if you're involved. And again, that's my opinion, purely because I don't have a body of case law I can point to about that. but we're moving out of the world of duty of care in terms of when the conduct that is problematic occurred. And then finally, with an existing or new client who's engaged in illegal activity without any role from the therapist, there's obviously no issue at all in terms of legality or licensing. So that gives you the kind of whole range of this.
And just if I just wanted a time check, we're at the 40 mark for possible Q&A, but just I don't know how much more time you have left here.
Let me do about 5 minutes and I'll wrap this up.
Okay, cool. Yep.
If I can. Okay. So how do people get caught? And this is a big issue here. Again, I'll analogize back to the work I did with cannabis. There are people who are very visible and they attract attention. And then there are people who generate complaints. In the world of cannabis growing, it was people who didn't put up their charcoal filters and didn't basically engage in behaviors to mitigate smell, and they annoy their neighbors. With therapists, your nightmare scenario is a client complains to a board or to the police. Now, we do have a good example of that. There's a woman named Frederica Fischer, a German therapist, and this is a Swiss case from some years back. And she was treating a couple with MDMA, a married couple. And during the course of that treatment, the husband decided to leave his wife. And with that, she reported the conduct to the police. There was a criminal trial and she was convicted. The therapist was convicted there. So those are essentially the two ways, in my experience as a criminal law lawyer, people end up in criminal court: high visibility or pissing somebody off, in plain English. Unfortunately, that means you have to look at your own clients and ask, who are these people? Who am I dealing with here? So my concluding remarks here are, for yourself, I think there's two things every therapist should do, or everybody working as a counselor in this field should do. First off, do an objective risk assessment of your own behaviors. Okay, I've just given you a nice, straightforward template of criminal conduct and professional licensing. Evaluate your current practices. What are you doing right now? And then do a kind of risk assessment. And then once you've done that objective risk assessment, do a subjective risk assessment for yourself. Because one size does not fit all. A 70-year-old therapist who doesn't care about their license, who already has all their debt paid off and is going into the twilight of their career, may have a different attitude about professional licensing boards than somebody who's 35 years old with $150,000 worth of debt and 2 kids. So the risk profile that we all have is the same in the sense of, the conduct and the penalties are the same, but our risk tolerances are different. And that's a very personal decision. And this gets us essentially to the end of our legal analysis here, where whatever choices you make, I hope you're all safe in your travels and wherever your heart takes you with this, with good information. So that's it.
Awesome. Thanks so much. This is so informative and so much useful information.